Courtroom 2B at the Fulton County Courthouse was packed. Onlookers whispered to one another, anticipating what many assumed would be a routine civil dispute. The plaintiff, a local development firm, was suing Dr. Malcolm Keyes for breach of contract over a land use disagreement. What the firm hadn't expected was that Dr. Keyes, stoic, poised, and dressed in a crisp navy suit, would elect to represent himself in court. The lead attorney for the development firm, Gregory Langston, entered confidently. A high-powered litigator, known for his aggressive tactics and love of courtroom theatrics, Langston was already anticipating an easy victory. After all, he was up against a defendant with no visible legal team. But what Langston hadn't done was read Dr. Keyes's full biography. Malcolm Keyes wasn't just a property owner. He was also a tenured professor of constitutional law at a prestigious university, a former clerk for a federal appellate judge, and the author of multiple law review articles on due process and civil liberties. He had spent the past 20 years teaching courtroom strategy and legal interpretation to future attorneys, the very skill Langston would now try to challenge. From the opening statements, it was clear Langston had underestimated him. "Ladies and gentlemen of the jury," Langston began, pacing dramatically, "the facts are simple. Dr. Keyes signed a contract, then he broke it. This isn't a constitutional debate. It's a case of a man who thinks he's above the law." When it was his turn to speak, Dr. Keyes stepped forward slowly and calmly. "Counselor Langston says this isn't about constitutional debate, but I beg to differ. At the heart of this case is the question of property rights, local ordinance overreach, and the protection of individual autonomy. That, ladies and gentlemen, is constitutional." The jury leaned in. So did Langston, though his smirk had started to waver. As the trial unfolded, Langston repeatedly tried to rattle Keyes. He objected to minor procedural moves, interrupted cross-examinations, and even asked condescending questions like, "Do you understand how contracts are enforced, Professor?" But Dr. Keyes never blinked. "Counselor," he responded smoothly, "I teach first-year contracts. If you'd like a lecture on mutual assent or consideration, I can draw you a diagram. But for now, let's stick to the matter at hand." Even the judge raised an eyebrow, barely hiding a grin. At one point, Langston introduced a key clause in the contract and attempted to corner Keyes on its interpretation. "This clause here, the seller agrees to relinquish all rights to easement access. Do you deny agreeing to that language?" "I don't deny it," Keyes said. "I contest its enforceability. That clause violates Georgia state law regarding landlocked property access, which I'm sure you'll recall from your bar exam prep, yes?" There were muffled laughs in the gallery, but the trial was no joke. Keyes produced city zoning maps, public records, and communications showing that the development firm had misrepresented the planned use of the land and manipulated permitting language to pressure him into relinquishing access. His arguments were clear, evidence-based, and devastatingly effective. After 4 days of proceedings, the jury deliberated for less than 2 hours. Verdict: in favor of the defendant, Dr. Malcolm Keyes. Not only was the suit dismissed, but the judge also admonished the plaintiff's legal team for bringing a case that bordered on frivolous. After the ruling, reporters gathered outside the courthouse. Langston exited quickly, head down, declining to comment. Keyes stood at the steps, answering questions with his signature calm. "I represented myself because I believed in the integrity of the process," he said. "I also wanted to remind people, especially Black professionals, that knowledge is a form of power. Sometimes the most radical thing we can do is know the law better than those who try to weaponize it against us." By evening, the story had gone viral. "Man schooling the courtroom. Constitutional law professor beats top attorney in court." Law students began circulating clips of Keyes's rebuttals, and legal TikTok was abuzz with admiration. Civil rights groups invited him to speak, and universities requested guest lectures. But Keyes wasn't chasing fame. He returned to his classroom the next week, just as he always had, standing before a new class of students. "Lesson 1, he said, writing on the board, "never let them mistake your calm for ignorance or your title for weakness.